Well, first of all, I'm very pleased to be in Belfast. It's my first time, and very thankful for the invitation by, well, Billy, who is a co-author as well. We have a chapter together, and also to have the opportunity to visit the school and to interact with people online. So today I will present my forthcoming book, as Billy mentioned, and I would like to start by kind of situating the discussion on what is the importance of this topic at the current time. I'm here when I talk about polycrisis. This is a deliberate choice because I think, and that's something we talked about in our joint work together with Billy. We're developing the concept there. This, of course, this is it's being very much used across the social sciences, and I think that there is a dimension in the idea of polycrisis that we haven't explored enough, which is a crisis of multilateralism embedded within the crisis that we have. It's not only the intersection of multiple crises, but also the difficulties that arise when we have a sort of multilateral a situation where it's difficult to coordinate. And I think this is sovereign debt is one of those. We are at a stage where the percentage of IDA, so that's international development assistance, eligible countries are at either at high risk or already in debt distress has doubled since 2015. This is, we'll discuss the reasons in a minute, but for example, this is reflected in the World Bank's International Debt Report, the latest one, late 2024, where the World Bank indicates that as a result of the withdrawal of private capital from emerging and developing countries, multilateral development banks and multilateral institutions have now become de facto lenders of last resort. And this is a devastating diversion of resources from areas critical to development, and also categorized the current stage we're at as a metastasizing insolvency crisis that continues to be misdiagnosed as a liquidity problem. So I think we are, as we are seeing, like recently announced cuts, not only US, I mean also at their UK add cuts. So we are also at a stage of a kind of crisis of concessional resources and international development assistance resources too. We don't know what's going to happen in the world economy, so it's difficult there to predict, but the dollar may also change in terms of, as a result of the trade tariffs. This may lead to soaring dollar too. In any case, I don't think the situation is going to get any better due to various factors. And so I think this is something we really need to consider as a kind of strong factor in this polycrisis age, because it has spillover effects in terms of social and economic stability or instability thereof, and impacts at a global governance. So here, this just, I don't know how much you can see there, but the graph on the left shows how interest rates have increased since the pandemic. So this is behind one of the crucial reasons behind the rising debt levels. It's not a matter of fiscal imprudence or, like all the stories we hear sometimes, how sovereign debt crisis may be created by kind of governance problems in the countries that suffer this crisis. This is very much around the idea of global liquidity and how soaring interest rates, because the interest rates have increased in core countries, so it's a matter of monetary policy of core countries, can also affect the cost of financing for the monetary periphery. It's not about fiscal policy necessarily. In this case, we have soaring costs due to interest rates, and this affects both bonds, the rollover bonds, and also loans when the interest rate is a floating rate. And UNCTAD shows, these graphs shows how in many countries interest rate is now the expenditures in interest rates are now higher than in crucial areas such as education and healthcare. So also shows the graph at the bottom right, how this also diverts resources away from crucial investments in climate adaptation and mitigation, for example. So this is very much at the heart. What I'm trying to kind of show with these graphs is how this is at the heart of so many of the crises we are facing today, and really kind of dealing with the problem of sovereign debt crisis is crucial to achieve several goals we have in global governance and several kind of sustainable development goals. So this is something, well, just to present, is something I'm dealing with in this book I aim to publish soon, discussing here fundamentally what is the role of law in this conversation, both kind of creating, shaping, and also potentially resolving sovereign debt crisis. And I'm trying to kind of develop a legal political economy framework to analyze these problems. What are the distributive dynamics of debt restructuring? And here I'll try and persuade the audience, both online and in person, that we need an international sovereign insolvency framework to deal with that. And I'm presenting that kind of the general idea, the kind of some of the general concepts. Here I'm trying to integrate this in broader conversations I'm sure you are familiar with to different levels, so that the audience can engage as much as possible. So let's kind of think about, let's think about kind of broader approaches to the problem of finance, the legal political economy of finance in general. I'm sure you are familiar with kind of this range of scholarship, particularly post-global financial crisis, but also during COVID, kind of post-COVID and contemporary research. We see this kind of a line of inquiry around inequality and how inequality has been increasing and the implications of inequality. That line of inquiry, of course, is in the social sciences in general, including economics. You know, for example, Piketty, the Capital in the 21st Century, was a very kind of important book there, which in a nutshell says, you know, the crucial point there is that the rate of return on capital exceeds economic growth, and this leads to rising inequality. So that is a very important and interesting point. And I think this has also inspired a line of research in law, which fundamentally kind of says, okay, sometimes economists tend to sort of reify things or kind of naturalize phenomena. I'm not saying Piketty does that necessarily, but I think there is a lot of that in kind of economics to say, okay, the rate of return on capital exceeds economic growth, but what is the plumbing of this situation, like legally? How can this happen? Like, what is the underlying what are the underlying kind of infrastructures that lead to a higher return on capital? So I think this has inspired kind of many people in law, but I will here focus on people who are doing finance, kind of particularly. And I think of interest here would be, for example, Karina Pistor's The Code of Capital, which is, of course, it's not framed as a response to Piketty or a kind of direct dialogue, but I see them in direct dialogue there, which is, yeah, the reason why the rate of return on capital exceeds economic growth is because due to capital's ability to generate wealth, but that fundamentally relies on its legal codification. And law determines who benefits from liquidity. So that's very important for Pistor because she's at least the Theory of Finance, which is a paper launched before that book, talks about the ability to create liquidity at the top, like the intervention of central banks during the crisis, for example. But fundamentally, there is this idea of law determining who benefits from liquidity and who does not. So there is this dichotomy between flexibility and rigidity. She focuses on how law creates flexibility at the apex of the system, which I think is, for me, is a good point to kind of pose this question. But what about kind of a global account of this phenomenon, right? Because the ability to create liquidity at the top of the system, in that case was very much focused on kind of core central banks in developed countries. But what about a global account of that? How does flexibility, liquidity, rigidity apply to a kind of global understanding of this problem? And what about, and in which ways, if law creates flexibility at the core, in which ways does it create rigidity in the periphery? What are the kind of infrastructures that determine this rigidity? So this is what I'm trying to do here in a certain way. The first thing I would like to, before we jump into this, to say, well, it's not even before, it's one of the core contentions of the book, is that the reason why we need to deal with sovereign insolvency problems is because they are systemic, they are adherent to the international monetary system, the way we know it today. Sometimes sovereign insolvency in the literature, or kind of the more conventional approach to this, tends to see the sovereign insolvency crisis as either the product of misfortune or mismanagement. So misfortune increasingly associated with wars, but also climate disasters, but also mismanagement like corruption, etc. So austerity sometimes may be seen as a measure of responsibility towards creditors being in an episode of mismanagement, even though this may be the case in certain situations, and that definitely can be behind certain crises. There are structural issues that underpin the international monetary system, which generate sovereign insolvency and sovereign debt crises. And the reason for that is sovereign debt markets are hierarchical in the same way as any debt market. Karina talks about that a lot in the context of private markets, but they are hierarchical in the sense that they're also shaped by asymmetries that consolidated in the post-Bretton Woods system, meaning basically you have a kind of counter-cyclical effects of liquidity. So when there is a crisis in a moment of uncertainty, liquidity will withdraw from the monetary periphery towards the core, seeking safety. So that's the flight to safety. That generates several issues. First, even the fiscal ability of states to deal with, to finance their general activities will be constrained, but also rollover ability will be constrained. And there are uneven access, channels of access to the global financial safety net. So that generates systemic kind of vulnerability to sovereign debt crisis, because liquidity and solvency are attached, very much attached. So this is the first point. If this is a systemic feature of the international monetary system, we need a legal framework to deal with this problem, because it's not going away. It's just part of the general functioning of the system. So here we see, it's a bit like what I was mentioning before. So there is heightened vulnerability to sovereign debt crisis. This graph kind of shows how, for example, during once the interest rate was raised in the kind of monetary core, this has led to negative financial flows from the monetary periphery to the core. So there you see, how this plays out in practice. So the result of that is that sovereign debt crises are not just a fiscal policy failure, but also they reflect the systemic architecture. So this is one of the core points, right? So if this is a systemic problem, we need a legal framework to deal with this. So what is the role of insolvency law in this conversation, right? Because the book is, I talk about we need sovereign insolvency law. So what is the role there? Well, first of all, kind of also drawing on economics research here, you'll be familiar or not with Minsky, who is a kind of prominent US scholar in economics, and not only Minsky, but prominently Minsky posed that financial crises are inherent to the cyclical dynamics of capitalism. And I don't think this can be challenged because you can have different approaches to that, but since capitalism emerged as a system, this has been the case. So During such crises, if rigid adherence to pre-existing commitments there risks are exacerbating economic downturns and also hindering collective recovery. So here, the idea is that the intersection of law and finance there, right? So you have financial crises, which are cyclical to the dynamics of capitalism, and you have this dichotomy between the need to ensure legal certainty in commitments, which is basically contract law, in a way, right? So you have an enforcement framework for contract law. At the same time, there is a macroeconomic effect of rigid enforcement of these commitments. And then that's where insolvency law emerges, which there to ensure it's an element of the financial architecture, because it mediates between the enforcement of obligations and the need for flexibility during crisis. And the way it does this is by, for example, this is prominently also suggested by Warren. Insolvency law here provides an escape valve for the enforcement of obligations. So it is a key component of the enforcement system. You have, on the one hand, in the enforcement system of contract law, you have commercial courts enforcing commercial agreements. At the same time, you have insolvency courts providing the escape valve. So they are also a part of the enforcement framework. And they allow claims to be suspended, negotiated, renegotiated, and reprioritized when their regional terms become untenable. And so it's a vital mechanism to manage and redistribute financial losses, as well as to ensure macroeconomic recovery. Interestingly, though, and this is part of discussions on insolvency law per se, this is not available for everyone in insolvency law. So the interplay between rigidity and elasticity is also central to broader discussions on insolvency law. Some, for example, I guess most people are familiar in the United States, for example, student loans are not included in insolvency framework. So this is an exclusion that the law does, right? So some people can benefit from the protection of insolvency law and others don't. And this also applies to private individuals, but in the case of sovereigns, prominently, that's the case of sovereign debt. Sovereigns are completely excluded from the protections of insolvency law, either internationally, but also legally. For example, in the UK, you have restructuring mechanisms for corporates, but not for a sovereign issuing a bond under UK law. So, but you do have even for a foreign company in certain circumstances issuing a bond or holding debts under UK law. So it's an exclusion from insolvency or broader restructuring frameworks. So now, how can we kind of approach this problem? And I suggest approaching it from a commons perspective. So the concept of commons has been developed particularly in institutional economics. Some of you will be familiar with it. The commons is a place or a sort of resource where no one can has the right of exclusion to others, right? Property or exclusion rights over anyone else in particular. So here we have, for example, grazing lands. You have people there who bring their cows to the land. No one has the right to exclude anyone else. And Garrett Harding, prominently in the 60s, posed that without enforceable exclusion rights, individuals interacting with a shared resource are incentivized to overexploit it. And this is an interesting point, because then this has kind of triggered a sort of debate in institutional economics, which was also addressed by Ostrom, who won the Nobel Prize of Economics for this book, Governing the Commons, responding to kind of this tradition. And she says, well, the fact that the incentive to overexploit a resource depends on the institutional arrangements that regulate the extraction of the resource, the monitor the use, and also enforce those rules. So these are the working rules. it's very interesting to draw, I think I draw upon this concept for law too, because the working rules there can be either kind of either customary rules, non-written, it's just what I think what some people in law will call the material constitution, right? They just exist in a certain way, or they can be formal frameworks. So the working rules do not necessarily need to be a formal kind of framework. If that's the case, and we don't have an insolvency rule for sovereigns, so there is no comprehensive mechanism that brings together a kind of collective mechanism to restructure debt, what are the working rules of sovereign debt restructuring then? Like if you think about it, if you think about sovereign debt or the kind of public resources as the grazing land where everyone will kind of draw upon this resource to kind of repay debts or finance public services, etc. And what are the working rules for the distribution of losses when there is an insolvency crisis there? I think there we have to do a sort of analysis which is based on how the system works in practice. And this is what I'm trying to do here. So thinking about sovereign insolvency as a common pool resource, right? Sovereign resources as a common pool, and then the governance of this process. If in the absence of insolvency rules, my core argument is that the governance of sovereign insolvency evolves into a sort of de facto working rules, and they are shaped by multiple domestic and international legal frameworks. So it's rational stakeholders. So here, I don't think it's about, kind of pointing fingers on, creditors are bad or etc. It's rational to behave like Hades over grazers in this situation, prioritizing own recoveries over kind of the general collective welfare, because this is how it's an institutional kind of incentive to do that. So the result of that is a self-reinforcing cycle of over-appropriation and depletion of resources. So that exacerbates also inter-creditor and inter-stakeholder inequalities. And because certain countries are more subject to sovereign debt crises, as I discussed earlier, the result of that is a sort of system of dysfunctional rules that entrench a systemic rigidity for those countries, and disproportionately burden states in the monetary periphery, which are more subject to those crises. So here, I tend to categorize the kind of two types of stakeholders. You have non-creditors, so they have kind of lawful claims on fiscal commons, which are governed by domestic law, international law, like, for example, wages, public services. This is all grounded on legal frameworks. At the same time, you also have creditors holding contractual or quasi-contractual claims here, like, for example, IMF loans, including commercial, bilateral, multilateral creditors. And then the kind of the working rules will depend on who has more legal leverage to overgraze, right? It's this kind of takes us to kind of two different tragedies, I think. One is a tragedy of the commons, which is not new in scholarship, but essentially the idea here is that the absence of working rules able to transform this destructive competition into cooperation leads to stakeholders trying to shift costs into each other. So the first one would be into non-creditor stakeholders in the form of austerity, for example, but also creditors between themselves, and that's what we are seeing now emerging in the, for example, G20 Common Framework, where you have an attempt to minimize losses through kind of new contractual arrangements, like most favored creditor clauses, but also state contingent clauses. So this is one way. I can elaborate on that later. But also we see a tragedy of the anti-commons, which is a situation that happens, it's the opposite of the commons, in which everyone has the power to block processes. So, and that's what we also see in the common framework, why we are seeing increasing delays in restructuring processes, because everyone kind of vetoes everyone's terms of negotiation. So that is another one, and we can discuss that later. But it leads to this dual tragedy in the sovereign debt architecture. In this situation where the tragedy of the commons and anti-commons, particularly the commons, we see the emergence of the kind of de facto priority in the working rules. And you can do that via contractual arrangements, but also litigation strategies. Like, for example, collateralization structures that we see kind of re-emerging in the sovereign debt landscape. You can for example, through litigation strategies too, either before an agreement is reached or post-agreement, and we can discuss that later. But the point here is you can, even in the absence of formal priority rights, and you can create de facto priority via different mechanisms. And it's all about your ability to leverage these priority rights. So we see that in terms of litigation tactics, this is just an example how you can create priority through litigation. This is very much used by the commercial class, commercial creditor, the class of commercial creditors. And we see that how lawsuits have increased as commercial creditors became more prominent in sovereign debt markets. The distressed debt funds have become the dominant type there, but this is a way of also kind of having shifting costs into other creditors. I'm conscious about the time, so I'll skip the discussion in detail about Zambia, but Zambia is a good illustration of what I'm saying, both the tragedy of the commons and the anti-commons, because you will see that the debt profile there is very much split into thirds. So that's the typical kind of post-COVID restructuring that has led to significant delays where creditors have had a very difficult time agreeing on the terms of the restructuring and how to measure comparability across creditor classes, but also significant delays which kind of illustrate the point of the tragedy of the anti-commons, where everyone can veto everyone's restructuring terms. And we can discuss that this shows how the delays, how restructuring processes are taking longer than post-COVID than in the previous era. And this is predominantly because we have more complex creditor composition, where China has become a prominent creditor on the negotiating table. But yeah, I would leave that for later. So what can international law do to address the kind of dual tragedy? And here I must say, I don't expect international law to kind of completely solve this problem, right? We have similar problems in insolvency law too, so it's not a kind of miracle. But an insolvency framework would address, or at least mitigate, this dual tragedy on the one hand by enabling class-specific negotiations, while eliminating holdouts through the kind of imposition of binding rules of engagement. So here, I think ideally there should be binding rules to engage with the process and not hold out, but not necessarily. I think it should provide flexibility in terms of how the proposals are made. So the rigidity should be in binding stakeholders into the process, but there should be flexibility in terms of how the restructuring terms are proposed in each case, because it really depends on the debt profile and priorities of the country. But the class-specific negotiations would be a way to go forward, and to impose a standstill on debt enforcement actions during this process, because by doing so, it also incentivizes creditors to engage. I also believe incorporating a sort of cross-class cram-down mechanism there would prevent any single class from exercising veto power in the negotiation. And this would ensure that the restructuring arrangement also upholds debt sustainability in the end, because it's not about only making sure we have intercreditor equity, but there should be a mechanism to ensure that the final outcome of the restructuring is sustainable for the country, which is a problem of the common framework right now, because the final outcomes are suboptimal. So I don't think this should be necessarily purely an international framework. We are not in the era of treaties anymore, right? I don't think this is a, I think domestic law has a crucial role there. First, because sovereign debt is basically a contract governed under domestic law. So there should be a cooperation, very much like the G20, for example, post-global financial crisis, had the kind of financial stability board agreeing on debts on rules around financial stability, which are implemented by domestic law, right? So here, I think there is a crucial role for implementing those agreements. First, ensuring that the standstill holds during the restructuring process, and then also limiting creditor recovery to the terms of the restructuring. So you have an international forum to negotiate and a kind of decision-making body there, but then you need a level of implementation and enforcement in domestic law if you're not doing this via treaty, right? So I think this, for me, is, I guess, I would suggest this is the most sustainable or the most, the sort of realistic plan, I guess, for a harmonized approach to sovereign debt workouts. And here, there would be no substantive interference with the terms of the contract. It would be a sort of safe harbor legislation just to make sure the terms of the restructuring agreed internationally are applied in the relevant jurisdiction. We don't have that under New York law. Well, just to situate, if you're not familiar with this, but most sovereign debt in foreign currency is either under New York or English law, right? So these are the most important jurisdictions in this regard. We don't have that type of legislation in New York law. The UK has enacted legislation limiting recoveries through the UK Developing Countries Act 2010, but the scope was limited to pre-204 debt. So 20 that was the HIPIC initiative, right? Debt that was acquired by highly indebted poor countries and was subject to the HIPIC multilateral debt relief initiative. So this act is no longer really, it's in force, but due to the scope of the debt that it involved, it's no longer relevant. So I would just like to kind of briefly mention that we do have this project, the Debt Relief Developing Countries Bill. It's scheduled for debate in the UK Parliament, and it's an attempt to kind of illustrate a bit what I'm trying to say here. It's not an insolvency framework, but it is a kind of safe harbor legislation which seeks to make comparable treatment standards under G20 Common Framework debt treatments enforceable under UK law, and also to impose a standstill on debt and security enforcement during the restructuring period. I can answer questions about that if you're interested, but the official text is available on the UK Parliament website. So this is all for me. I apologize for the slight delay, but happy to answer questions from both the audience and online and here. Thank you.
Thank you very much, and you were perfectly on time. There's no problem. This was an excellent presentation and it's really important work. So I can't wait to see the book. I'm sure you can't either.
Yes.
So I'm going to start off with a very brief question, and I'll give time for the rest of the audience to gather their thoughts. So I was interested in the last slide. You're talking about the role of domestic law, and I was interested because it made me think of the role of domestic debt, right? And I'm not sure to what extent this is something that you're focusing in your work, because it seems to be mostly about debt that results from external obligations. And so I was thinking, coming from a country like Cape Verde, I know that in a lot of African countries, although much of the narrative is about, international debt, but actually a lot of the problems are actually domestic debt, right? So like the rising cost of, benchmark interest rate, because of, local currency. So, the cost of servicing local currency. So I was wondering, to what extent have you looked at that domestic debt, and to what extent does the experience of domestic jurisdictions in dealing with those issues can be useful in terms of your research, can be transposed at the international level?
Yeah, no, I think it's a very important point because particularly so-called emerging markets, there is this increase in domestic debt, but not only, you see domestic debt in some low-income countries too. For example, the Zambia restructuring, that was an issue because there were the question of whether it should be included or not was an issue. The IMF wasn't sure whether to include this in the debt sustainability assessment. And the back and forth created kind of financial instability in the country too. So that's it's a very important point. And I predominantly don't focus on domestic debt because when I talk about the rigidity in the law, this is basically because it's what we know as a kind of legal form of original sin, right? Original sin is a term in economics that talks about how being indebted in a foreign currency creates several issues. And it's original sin because it's at the core of several macroeconomic problems. And a legal form of original sin is when precisely you defer, to another jurisdiction. And then when you have a macroeconomic problem, you have no tools to deal with it. The other jurisdiction does not offer, in this case, any tools. So that's at the core of the problem I'm looking at. But I really understand, domestic debt is crucial. In principle, you could deal with that through your own domestic legislation. And that's, for example, an interesting illustration is Greece when during the European debt crisis, because Greece was able to restructure the Greek law bonds by introducing collective action clauses ex post. So they were introduced after the bonds were issued, so via legislation. But they weren't able to restructure some of the issuances of English law government bonds because the creditors blocked the restructuring. So that's just to illustrate. So in principle, you could deal with that through domestic law. Of course, this is not how countries are generally dealing with this. But it's a kind of political economic decision within the country to sort of impose more austerity to service the debt or not. But also it depends on the debt profile, because it can pose financial stability concerns within the country too, because particularly the banking system. So it's a different consideration. But I think if we talk about, if we move towards a framework that deals with the debt, I think at the very least, the terms offered to domestic creditors would have to be discussed. I think domestic debt will have to be, I think this is a matter of policy, right? But my take on this, I guess if we had an international framework for this, domestic debt would have to be dealt with first. And the terms of this restructuring, I think, would be consideration in terms of intercreditor equity in the international mechanism. But yeah, I think the fora for discussion would be different purely on the basis that you can deal with that via legislation.
Yeah. Got Regis Seymour, he's a lecturer here at Queen's in international trade law.
Yes, I think we were presentation, that was very interesting. I was just wondering, I mean, to excuse my ignorance, but I was wondering whether when you speak about international framework, you also consider international institutions that will be in charge of monitoring such a legal framework in place. And I cannot help but think about my own area of research, trade law. If you were to suggest, I mean, if this type of framework is to be implemented, are you kind of seeing in the sense of having a highly indebted countries type of framework that only takes into account that type of countries, or is it an all-encompassing law that will govern any type of debt, no matter the level of development of that country? So,
Yeah, in terms of international institutions, well, it's really and in connection with your own expertise, I think it's really interesting to draw this kind of very significant distinction in trade and finance, because you have a unified framework for trade, which is a kind of coherent. It can have problems, we can critique, but it's there, right? For international finance, we have, on the one hand, it's very fragmented. We have several different institutions, but also kind of non-state actors, kind of not necessarily international institutions in the sense of formal international law. But in the case of sovereign debt, it is a gap, because the IMF does not have a legal authority to conduct restructurings. They have the authority to conduct debt sustainability assessments within, at least in principle, within the scope of their decision making to either provide financing or not to the country, and the debt sustainability assessments end up kind of shaping the restructuring process, because that's the only game in town, really. So I think the IMF should continue doing its work there, but the IMF has sought to have the authority to conduct restructurings before. That was in the early 2000s. The proposal was rejected by different actors, predominantly the US Treasury, but also other, and even countries sometimes, I think, are kind of concerned about that. But I think, I kind of mentioned that briefly in the presentation. I think we are not in the era of making treaties anymore, so it's not realistic. I think what I would suggest as a realistic plan would be to have an international body that is able to conduct this process, and the enforcement would have to be at a domestic level. But that's really my own reflection on this. So yeah, in terms of institutions, I think it would be another institution of these kind of soft institutions of international finance. Of course, this brings issues in terms of we don't want to have a kind of an exit panel there making decisions purely based on their own rules without regard to the domestic law of the country. So it needs to be a body that takes into consideration the proposals made to the credit to ensure inter-creditor equity, but also I think my suggestion would be for a more flexible framework that is not necessarily as strict as exit panels based on investment treaties. And I think domestic law, going back to your question, also has a rule there, because I think countries should have their domestic law rules to determine the terms of restructuring proposals. I think, for example, if we want to have a kind of a threshold kind of social expenditures, etc., or how they should be conducted, I think countries should have this kind of codified in domestic law to kind of bind their executive powers in in each case. And this could, I think, would be more enforceable at the international level too, to say, okay, this is the rule, so I'm doing it according to the rule. But it's a difficult question. What is the second part? I'm sorry, I missed it.
Yeah, I wonder whether you envision this kind of law, do you only focus on highly indebted poor countries?
Oh, yes,
Or
yeah.
you think something that should be applicable to every type of debt indebted country?
Well, I think I wouldn't restrict it. Of course, the monetary periphery is more subject to those problems. So I think the stakeholders, the users of the system would be monetary periphery more significantly, but it doesn't mean we won't see that problem. I just don't think this is the usual way. If you have a kind of certain level of monetary power, you will deal with that. It will be much more. You will have much more domestic debt first of all. So it's not an international. You won't be subject to foreign jurisdictions there. Overwhelmingly, even in the European Union, the overwhelming majority of the debt is under domestic law. So but it's not. There wouldn't be an exclusion. There is just a different debt profile. Yeah.
No, sorry, go ahead. Go ahead. Thank you so much, Karina. It was really, really interesting. And I have another question again on the international rule. I really liked your suggestions how international law can address that the dual tragedy that you explained. But as you said, it cannot be like a magic wand, to fix everything. So I was just wondering, what do you think are the main remaining challenge, to develop this international sovereignty framework you suggest?
Mm-hmm. Yeah, I think the main challenges would be some of them connected to usual insolvency law discussions, like for example, the distribution of losses among creditors. And this is something that we are seeing today in the context of the common framework, the G20 common framework, for example. The common framework is a sort of kind of round table which brings together Paris Club creditors, traditional kind of Western creditors, Chinese creditors, which are not part of the Paris Club. Also because there are other creditors which are not part of the Paris Club, like India, Saudi Arabia, but China, in the context of the current restructurings, is a prominent creditor because there are policy banks that have provided loans and are now, or two countries that are now having to restructure their debt. So and they seek to bring together commercial creditors too, but that's a difficulty. And the main discussion at the G20 level is is there a metric you can use to assess comparability of treatment? And since this is all kind of consensual, it's often complicated because creditors have different preferences. For example, bondholders tend to prefer, bondholders meaning institutional investors holding those bonds tend to prefer immediate liquidity. They want to be paid as soon as possible. They don't mind necessarily providing kind of relief in the principal, provided they can get cash earlier. Chinese creditors, on average, they are very reluctant to provide any reduction in the principal, but they are happy to extend the maturity. For example, in the Paris Club creditors have kind of developed a practice of providing that was in connection with the highly indebted poor countries initiative, for example. So they developed this idea that, to achieve that sustainability, we need to reduce the principal. And then because the Chinese creditors are not happy to reduce the principal, they say, we are subsidizing you then because we are kind of reducing the principal and you're not. But then the Chinese creditors say, but you are not enforcing your commercial creditors, like the participation of your commercial creditors to join. So I'm actually subsidizing them too. So this is all, it's really a prisoner's dilemma there in terms of cooperation. So I think one of the difficulties is to assess that, But that said, I think there is a lot we can draw on in terms of the experience of corporate restructuring to assess that. We were having this conversation earlier before this talk, which is in some cases even the same creditors are involved in the same creditors involved in a sovereign debt restructuring are the creditors involved in corporate restructuring in the UK, for example, and the UK courts apply kind of standards like no worse off tests in the context of restructuring plans under UK company law, for example, to judge whether a creditor is worse off or not than it would be in the relevant alternative to the restructuring plan. So I don't think this type of reasoning is completely foreign to legal to restructuring processes. The difficulty here is really because everyone can veto the process. It's more of authority and enforcement than of really having conceptual coherence in terms of measuring whether someone is getting similar treatment, I think. So I think this is one challenge, is how comparability of treatment, but also the power to determine that. Yeah, I think this is the most significant challenge. Yeah, then there are other challenges that come from that, but then yeah, reaching a sort of level of consensus to establish safe harbor legislation at domestic level, of course. But we could evolve in this direction. We have model laws, right? Like we have UNCITRAL model laws for insolvency. Why not having UNCITRAL safe harbor legislation to implement that? We could have that.
Yep.
Were you next up? Or
Sorry?
yeah, were you next up? Yeah, I think so.
Sorry, I'm being extremely disruptive. Sorry about that. So what I have three kind of interrelated, well, two are interrelated, the third one isn't, as I was saying. So you mentioned the HPEC system and all the debt forgiveness systems that have gone before. And I was wondering, sort of in the sort of, even you could even throw in, say, the Millennium Development Goals and Sustainable Development Goals, and these sort of, do you think we're at a kind of an end of a kind of that kind of way? So not even, as you said, we're not in an era of treaties, but are we also at an end of largely unsuccessful processes of sort of seeing it through an aid lens? Because I mean, the way you're framing it is you're not seeing it through an aid lens at all, but all those other processes, we're very much seeing it through a development law aid process rather than a finance process. So I was wondering, do you think we've kind of moved beyond that kind of framing, and whether you think that's good or bad? The second question I have was, it was about a month ago, and the many crazy things that Trump said, but one of the things he said was that they'd been looking at their debts, and that some of the debts were fraudulent, and that they were just not going to repay them. Now, I'd imagine somebody in the Treasury Department went, shut up. Because obviously that would be a problem. But I'm wondering if say, I mean, they do lots of crazy things, right? So it's not actually, nothing is now beyond the realms of like possibility. I mean, he's big friends with the president of Argentina at the moment as well. So I'm just wondering what, like, that sort of, if something, we're already at a moment, as you said, we're not in a treaty or that kind of international cooperation. If we call it cooperation, it's not going to happen. But is there a potential moment of rupture where something like your model could potentially actually happen in the sense of that there isn't a sort of going to be a unified process? We have a lot of turbulence, we have a lot of debt authority around, and there are countries, because of security issues, that also potentially are going to, Germany is getting, I think, the vote today or yesterday about getting rid of their debt ceiling. But do you think that there's a moment maybe of rupture where potentially you could see this kind of thing happening as opposed to all the others? And what would happen if Trump tomorrow stood
sends out a tweet an hour and a second. We're no longer paying these debts back.
Yeah. On the first question, I think, I'm not mentioning that because, I think we are in a very different time, and I agree. I think it's even geopolitically too. I think, for example, the HIPIC initiative is a very much kind of peak of the kind of hegemonic era, like USA for Africa, all together, kind of. So I think this is not where we are at, which kind of poses several challenges. On the one hand, of course, because countries now, for example, I didn't have much time to elaborate on that, but with the cuts on concessional lending, we have several low-income countries with debt problems already, but the ones that are not, I think they will be also pushed to a costlier market-based financing as a result of not having concessional sources. So I think this will get worse on the one hand, but also I think in a certain way, it's a new moment where countries will really have to think about. It's more like there is room for creativity, but also kind of responsibility in a sense, not of fiscal responsibility, but of, okay, we really need to think about how to ensure we have a proper kind of development plan and cooperation with as many countries as possible. So, for example, in the context of the question on domestic legislation, what can we do to ensure that if we have a debt problem, the terms will be our leaders will be accountable to the population? Can we cooperate? I think in Africa we are seeing that kind of increasing cooperation around kind of creating capacity to manage debt and to restructure. So this is also like another dimension. But I think even what I'm fully conscious like that, even a proposal like this one, which broadly I think draws upon G20 experience post global financial crisis, is also challenging this time. We are not in 2008 anymore. So it's even, I think it's really, at the same time, there is nothing we can do but hope for some cooperation. So I think we need, I don't discard the need to ensure sustainable development goals, but I think we are in a situation that the situation for sovereign debt is so challenging that if we treat sovereigns in the same way as we treat companies, it would be already great. Because sovereigns are treated as companies, particularly UK and US law have evolved in a way that considers companies to be commercial entities for the purposes of entering into debt obligations, but they are not treated as such when they have a problem. So if we treat them at the very least, kind of develop certain mechanisms to at least enable them to restructure in a similar way, this would already be a developmental, I think, gain. And countries need to bear in mind developmental considerations when they propose plans to restructure. So I don't know, in terms of Sean.
Thank you.
Oh yeah, we are running a fact.
This is not your fault, it's Aoife's fault for having a three-pronged question.
You can answer it now.
Yes.
So all that's left for me to do is to thank Dr. Karina Ferreira Lima for a brilliant presentation and for taking the time to join us here. It's been an absolute pleasure.
Thank you. Thank you all.